and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. Welcome to the Appeals Court. Sitting with me today are Justices Rubin and Henry. Things will operate as they do normally, in that each side gets 15 minutes. We're not going to entertain rebuttal. Please be cognizant of when the judges are trying to ask a question. There's a little bit of lag time, but with that, I'll call our first case. That's 2019 P308 KM versus MM. I remember and I want to remind you that this is impounded, so please do not use any names. Mr. Trapp.
Good morning, Your Honors. May it please the court, Michael Traft on behalf of the appellant husband in this case. There are two aspects of the divorce judgment that we claim were erroneous and require a revision, that with respect to the division of assets and with respect to the calculation of alimony. Both relate essentially to a side business that the husband had with partners for real estate ownership and management. First, with respect to the division of assets, the judge recognized that the husband had, prior to the judgment, purchased a number of properties, prior to the marriage, rather, had purchased a number of properties, but did not account for the value of those properties in calculating the total value of the marital estate. He had owned the properties for several years. That he and his partners had made substantial increases in the value to those properties prior to the marriage. Now, what the judge said is that she couldn't determine what the values of the properties were at the time of the marriage because there had been no testimony specifically about that, but it was included in the evidence. The appraiser, yes.
So the judge actually said that the properties were incorporated into the fabric of the marriage, and then in parentheses said that there was not evidence of value. So is that an independent basis for the judge to not credit the husband with the pre-marriage value of the properties, that they were incorporated into the fabric of the marriage?
If she said that specifically and acknowledged that regardless of what the difference and how much the improvement of the value of the properties had occurred, that it didn't matter. But that really isn't what the judge said, as I read her judgment. I think what she was saying is, if perhaps I would have ruled differently had there been some evidence as to what the values of the properties were at the time. But since there wasn't, I really can't make a consideration of that. And that's where I believe she made the mistake, because when you look at the testimony from the appraiser, there's a specific testimony of what the values of the properties were during but the appraised value of the properties for each year. And actually might have been an appraised value rather than an assessed value rather than an appraised value, would have perhaps been less than what an appraised calculation might have been. But in any event, by saying that she wasn't going to consider it at all, I think that's where the...
Can you ask the judge to do this? Did you point the judge to these figures and say, look, this is where the value was on the date of marriage, and so, you know, we want you to start there?
Well, there was testimony about it, and there was, in the proposed judgment, there was discussion of the assessed value. There wasn't a specific pointing there on this page is the assessed value that is included in the appraisal, but the evidence was present and it was in the record and as part of an exhibit. So there was something that to be considered, and there was a request that there be a calculation to reduce the total value of the marital estate by the increase in the value for that period of time. So I believe it was adequately presented.
Do
Now,
you have a record site for where that request was made?
yes, in the proposed findings of the appellant husband's attorney. There's a specific discussion of that. Now, with respect to the other aspect of the calculation of the value of the real estate properties, the judge failed to consider the capital gains tax that would be involved in the assessment of the value of the properties.
This
Now-
is the most interesting question to me in this case, because I'm
Yes.
surprised at this late date that we don't have clearer guidance from prior case law about capital gains. So we have two different cases. We do have this case that says it's proper to consider the capital gains, even if sale isn't contemplated, capital gains taxes, even if sale isn't contemplated. But we also have a case that upholds a calculation where in the absence of liquidation, maybe it's the other way around, maybe it's going to be liquidated and it has to go in. I don't really understand how this works. If the husband keeps the property until he dies, his heirs or beneficiaries will take at a stepped up basis. There'll be no capital gains tax. If he holds on to the property at some length, I may be mistaken about this and you'll correct me if I am. While he owns the property, the full equity value of it can be used as, for example, collateral against loans, to the extent that rental property value, that there is a relationship between rent and the value of a property, which I assume is imperfect. I know nothing much about this. The pre-tax value of the property presumably is the one that would be reflected in the rental value. So how can we have a hard and fast rule that you have to consider capital gains tax? And if we stated a rule, when would you say it has to be considered and when not?
Well, in this case, I think it's clear that it has to be considered because of the way the judge divided the assets. Now, if the judge had divided the assets by saying, well, I'm going to give a portion of them to the wife and a portion of them to the, then each of them would take some of the capital gain of whatever property they received. And that's actually what was proposed by both sides. But here, what the judge said was, all right, I'm going to assess what the value of all of these properties are. And I'm going to avoid further conflict, I'm going to assign all of the properties to the husband and then add up what I consider the value and divide that. And what she considers it and give to the wife 1/2 of what that value is. Now, that's where the mistake occurs, because there is no way that the husband can provide that sum of cash to the wife without selling some of these properties. And in selling some of these properties, unequivocally, he has to pay a capital gains. There might be some theoretical.
That's a slightly different point. That may be true, and that may go to your argument about not taking account of the reduced rental income from the sale of the properties, all of that, including, I suppose, capital gains taxes. But he doesn't have to sell all of the properties.
Right.
Regardless, even if he, and I am not persuaded that he has to sell. Maybe he could mortgage them. I don't know enough about those circumstances. But even if he sells some of the properties, you're saying the capital gains tax should be deducted from the value of the other properties in the property division. Am I correct about that?
Yes, I am saying that with respect to all of them, because at some point that capital gains is an assessment that he would
not
have
if he not if he holds it until death, right? If he holds these until death, there's never capital gains tax, at least under the current tax law, right?
Well, you might be correct if he holds it until death, but that's it's kind of a different story here. You can't assume that he will. and that he will never.
Well, I don't know what to assume. He has valuable rental properties that are generating income. I don't know what he's going to do with them, and I don't know. Are there children of this marriage? I don't remember the.
Yes, there are two children, and there are expenses for.
So avoiding that
children.
capital gains tax might even be a reason to hold on to them until death, right? I mean, if one were doing estate planning, one might say, well, you take it a stepped up basis. You know, this is a piece of property you want to, you know, have in your estate. See if you can live off something else, you know?
Well, part of the problems that you have with real estate properties is that there are a lot of other variables that may go on into the value going on in the future. But
you might even be able to roll the profit into another, whatever that is, a 10J rollover. I don't remember what the numbers are, and avoid capital gains tax until the next property is. I mean, it all seems a little bit speculative to me.
Well, I think it's a lot more speculative to say, well, because we can't be sure what he's going to do with them, we won't consider any of it at all. And we will obligate him to at least pay some of the capital gains on some of the sale of some of the properties and not give him his share.
The judge did not order him to sell these properties, did she?
No, but she presumed, because of her knowledge of the evidence and the testimony of the value of the properties that were there, that there would be a need for him somehow to obtain these assets. And
where is that presumption? Is that stated somewhere in her decision?
Yes, because her judgment gives him 6 months to provide the money.
Well, yeah, but that also could be so that he could refinance.
If he could refinance. I mean, he's dealing with a situation where all of these properties are not owned solely by him, they're owned by partners. So there are a number of other variables involved on what he can do.
Right, and so I guess, I mean, I'm trying to understand if we were to agree with you, why she also gave the husband the benefit of a substantial discount on the value of these properties merely because he owns them with these other partners. That seemed very generous. And it doesn't seem like we should, if we were to agree with you, that we should unpackage just one small part of that rather than the whole thing. She did not have to give him that discount.
She could have given him a different discount or some kind.
Discount, because he's operating these properties with his friends and his partners. He has a good relationship with them, and they could have just reached an agreement. Instead, she gave him at least a 25% discount.
Yes, but this was a discount that was, as testified by his appraiser, which he determined was an appropriate discount under the circumstances. And I think that the difference is here, if the judge had said something different and said, I'm considering all of this and I will give this discount, but I'm not going to give any more for that reason, that would be one thing. But that isn't what the judge's decision was. She said, I don't know what the capital gains is going to be, so I'm not going to consider that at all. And I'm going to make an equal division of what I consider all of the assets.
And where's that statement by her on the record?
That's that's in the judgment, essentially, because she says the judgment in the rationale for the judgment says specifically that she's decided to calculate what is all of the income and then to equally divide it between the two parties, finding that that was an appropriate way to make the determination. Our argument is, if you're going to do that, that's perfectly fine. You could do something different and say, give a little bit more to the wife or a little bit more to the husband for whatever other reasons. And that might have been appropriate too, but that's not what she said.
So what's the standard of review on this, where the court specifically considered this issue and declined to consider hypothetical capital gains, particularly where she's wrapped it up with other determinations about the property, including giving this discount? Is this an abuse of discretion standard?
It's not an abuse of discretion. I believe it's a failure to adequately account for the particular facts, and that overall the matter has to be reconsidered because of the failure to consider that. I don't believe that the judge made a determination that I'm giving this discount and I'm considering all of these other things and putting that all together. That's enough of a discount of the value in my assessment of the value. If she had made that, you might have a different story, but that's not what the judgment says. And I think you have a responsibility where there's a factor that makes a difference on what the values of the properties are, that must be reconsidered in determining what's an appropriate division of the assets if you're trying to make an equal division. Now, if there are no further questions on that, I'll move on to the alimony calculation.
On the
I'm afraid
alimony
you're gonna be out of time.
calculation, did the judge's calculation assume the husband would stop working at the Boston Redevelopment Commission, but did that in fact happen?
It didn't happen. It was what was expected and anticipated at the time of the trial. And so that there's really no evidence about that that is in the record of the trial. It could be a basis for a subsequent modification, but it was something that was anticipated that he would not have that income.
Okay, your time is up, Mr. Traft.
All right. Thank you, Your Honor.
Mr. Powers.
Good morning, Your Honors, and may it please the court, Kevin Powers on behalf of the appellee wife. Your Honors, the husband presented a Byzantine labyrinth of financial data that minimized valuations and maximized expenses. Even the husband conceded in his opening brief at page 32, quote, "The husband's calculations of expenses could be criticized as excessive." Your Honors, there is no abuse of discretion here. There is no clear error here. And husband's arguments are without merit. We request that this court affirm the judgment below and award reasonable fees and costs of defending against this appeal. Your Honors, to take the issue of mortgage principal and maintenance and repairs first, Zaleski sets forth the standard of review. The judge has broad discretion when awarding alimony, and the judgment will not be disturbed on appeal unless plainly wrong and excessive. Here, the judge considered the relevant factors, and she exercised a reasonable discretion. On Record Appendix Volume 1, page 94, at paragraph C, the trial judge stated that the trial court notes that the court form CJD 301 Schedule B does not include a deduction for principal payments, and the husband's financial statement was manually edited to allow him to list this deduction. The trial court further notes that the husband's tax accountant testified that payments toward principal are not allowed deductions when calculating rental income for tax purposes. Then, Your Honors, again at Record Appendix Volume 1, page 94, paragraph D, the court further states there was no testimony or other evidence provided that such funds were actually being put aside in business accounts. The court finds that these are not appropriate deductions for purposes of calculating current income. The judge did consider these arguments. She did consider the evidence. She exercised her reasonable discretion. And given the standard of review, she committed no reversible error. Your Honors, as to
Counsel, so the husband argues that these appraised, the properties that he brought into the marriage, that the appraised values were before the court, and that he did ask her to take that into consideration, that it was all readily determinable. What's your response to that?
one moment, please, Your Honor. Your Honor, as to the 1996 property valuations, which I believe are at the core of my brother's argument on appeal, Your Honor, in both her findings of fact and at trial, The judge explained her reasoning for including the premarital real estate equity in the marital estate. And, Your Honor, the gravamen of that reasoning was not any lack of evidence, notwithstanding the parenthetical, which Your Honor noted in the findings of fact and rationale. The gravamen of her reasoning was, and I quote, Record Appendix Volume 1 at page 101, the evidence showed that those properties were incorporated into the economic fabric of the marriage, all appreciated significantly during the marriage. Then we have the parenthetical, but then she says, and equity from all was utilized to purchase marital property. This aligns completely with what the judge said at the very beginning of the first day of trial, when in a last-ditch effort to try to convince the parties to resolve this matter and to not engage in a 4-day, no holds barred, knockdown, drag out contested trial, she emphasized for all of the parties to hear at Record Appendix Volume 3, page 8, and then at page 12 to 13, quote, with the marriage of 17 years duration, I am likely to bring the vast majority of them in, them being the premarital properties. I mean, if I heard testimony that indicated a complete severing of something, no involvement in the marriage, no time on the part of husband working on them during the marriage, but it feels to me, and from what I've read, that these are essentially incorporated into the marital estate, and I would likely be doing that, and I would likely be doing a 50-50 division here. Then, at pages 12 to 13, she again states, I would most likely, sir, again, reserving the right to reconsider this after trial, but really, I'm saying this for everybody's sake here. I would most likely bring in 100% of your portion of these, not obviously what your partners own. Your Honor, further, the husband did not raise the 1996 valuations of the properties in his proposed findings. And therefore, Your Honor, husband at that point arguably waived this issue altogether. Instead, the husband at Record Appendix Volume 1, page 73, at proposed finding of fact 128, referred to the purchase prices of the properties, but not the 1996 premarital values of the properties. Then further on at Record Appendix Volume 1, page 74, at proposed findings of fact 129 to 133, the husband described investment improvements, but again, never asked the court to consider the 1996 property valuations. And again, 1996, the year that the marriage began. Quote, prior to the marriage, the husband and partners, and then the husband describes him and his partners using savings and income from 1986 to mid-1994 to purchase real estate prior to the marriage, to make substantial renovations to real estate prior to marriage, et cetera. But again, the husband was not pounding the podium and insisting that the judge consider 1996 valuations.
And they would have been more favorable, presumably, to the husband anyway, right? Because presumably the property appreciated between purchase and the date of marriage as well. I mean, I don't know, maybe 1996 is, maybe we don't, well, apparently we do know because there's assessed valuations in the record. But if the judge had wanted to, she could have used the purchase price and given the wife credit only for, I mean, for all of the increase from purchase rather than from the time of marriage. And that would have been more favorable to the wife than what they're arguing for now, right? Or maybe that what I said is too complicated.
Your Honor, I would defer to your Honor's analysis on that, but I would also place this squarely within the standard of review. That ultimately The judge was within her reasonable discretion to do the math in any of a variety of ways. The calculus that she ultimately exercised was eminently reasonable. In fact, she, as Your Honor noted, in many regards, she used valuations that were very favorable to the husband, and in fact took as her foundational valuations for the rental properties, took essentially the husband's assessor witnesses values. So she was very favorable to the husband, notwithstanding many problems and changes and alterations over time in the numerous financial statements and inconsistencies in the husband's financial evidence.
What is your position on when capital gains taxes have to be taken account of in valuing marital property?
Your Honor, they need not be taken account of, because ultimately, at best, they would be an estimate. And as Your Honor noted, if the husband held the properties until death, then there would never be a capital gains tax. Now,
but now we have MASA, which says that it's proper to consider capital gains taxes, even if property is not being liquidated. I believe Judge Cass wrote that opinion, and he said that it gives a more accurate valuation or something like that.
Your Honor, yes, Williams does state that, and I would again refer back to the standard of review. Just as it was not an abuse of discretion in Williams for that judge to take account of an estimated capital gains tax, it is no abuse of discretion in this case for the judge to decline to do so.
I just don't understand that. That suggests that a judge can do whatever she wants with respect to capital gains taxes. It seems to me that one way must be an error and the other way must be right, unless we have specific facts like it's about to be liquidated or it's never going to be liquidated, or, you know, those kinds of things. But if you're just presented with, oh, here's some properties and they've appreciated in value, how can it be within the judge's discretion to either reduce it or not? How can both be right?
Your Honor, the judge not only had to consider the possibilities of potential tax developments down the line, she also had to consider credibility issues, and here for her to take husband at his word as to what would happen with any given property over time, she tried in rigorous detail to examine all of the evidence, to try to see through attempts to maximize expenses and minimize valuations, and to try to arrive at the most accurate numbers possible. To then, on top of that, assume that the husband would necessarily be selling these properties, when in fact husband's counsel stated, if I may have just one moment, husband argued at trial that he could not in fact sell any properties. I believe it was husband's counsel stating at Record Appendix Volume 3, page 22, we can't sell the property because the property's owned tenants in common. And then at Record Appendix Volume 3, page 30, again, husband's counsel, we can't do anything with with Mr. and then naming the three real estate investment partners. So husband at trial was not arguing that he was not only that he would be forced to sell any of the properties and realize any capital gains taxes, but in fact was not arguing that he would be able to sell any of the properties, because as husband's counsel at trial stated, these were co-owned with other investment partners, and as they presented the scenario, those investment partners would not agree to sell. So if the judge here essentially took husband's counsel at his word, then she could hardly be faulted for that, and certainly could hardly be characterized as having abused her discretion to have done that. Your Honors, briefly, with regard to the argument about alimony double dipping, I would refer the court both to Delicio and to Cappuccino. In Cappuccino, this court held that there is no risk of double counting, where neither the value of the interest in the real property nor the party's ability to earn income is diminished by treating the party's interest in the real property as a marital asset, as well as a source of income by which the party can meet support obligations. In that case, it was child support. In this case, it is alimony. But the analysis holds. And then this court further stated that when recalculating,
your time is up.
Thank you, Your Honors. Your Honors, the wife would ask, on the basis of those arguments and the arguments articulated in our brief, that this court affirm the judgment below and award her reasonable fees and costs for defending this appeal. Thank you, Your Honors.
Thank you. Thank you both. We'll take this under advisement.
We are live.
Welcome to the appeal court. I'm Justice Meade. With me today are Justices Rubin and Henry. Each side gets 15 minutes. We do not entertain rebuttal. This case is impounded, so please do not use any names. With that, the case is 2019 P 368 John Doe 5447 versus the Sex Offender Registry Board. Mr. Burkholder.
Good morning, may it please the court. Fred Burkholder for John Doe 5447. I know you've all had an opportunity to read my briefs. I don't want to repeat them to you. I think we have a very novel issue that I wanted to bring to the court's attention. And as my esteemed colleague has mentioned, whether it is moot or not is a question for this court. The issue, of course, is the following, and that is whether or not an individual who at the time of the first of the two offenses that were the predicates for application of factor 2 was in fact 1 month over age 18. And my argument with regards to the mootness issue is as follows. The language that's contained within the case in which she cites, specifically East Chop Tennis Club versus Massachusetts Commission, says our court has long followed the rule that in the absence of statutory directive to the contrary, administrative remedies should be exhausted before resort to the courts. My direction to the court this morning is that the issue of age is one of the main directives of the statute, and as such, it should never be moot. It should always be there before the court's consideration.
Can I don't, excuse me for interrupting, but I have some sympathy with this argument, this emerging adult argument. But I don't see how in this case, when you haven't presented to the hearing examiner first, and then maybe the trial court, whatever evidence you have, studies and so on, about the nature of emerging adulthood, to allow the hearing examiner to say, well, okay, I get that under the word of the rules, 18 is the line, but I'm going to counted as a mitigating factor nonetheless, or I think it's required to be, or the Constitution requires it to be, or whatever. If you haven't presented that to the hearing examiner, this is a civil case. What can we do with it?
Two answers to your question. First of all, I did submit a summary of several studies along with this. And the question becomes, should that be considered? And there is case law that to the effect that says that when it's in the interest of, there's a public interest, new studies can be considered. Secondly, there is
I'm
case
sorry,
law.
Mr. Burke, where did you submit those?
Where did I submit those? I submitted one article as an addendum to my.
You mean you submitted them to us? You submitted them to us?
I did.
Oh, not
No,
either
I
to the
did
trial
not.
court or the hearing
No, I
examiner.
did not represent this individual.
Well, did anyone present them to the hearing examiner?
No, I did not. My argument is that number one, they can be properly considered by this court because they involve public interest. Secondly, there is case law that suggests specifically the following, and this is from the same East Chop tennis club case in which my sister cites, and it says, furthermore, even within the context of, and now those particularly tax cases, we have often emphasized that the ordinary requirement of exhaustion will be suspended only when the facts of a particular case raise important public questions. And my point here is that this is an important public question. The Massachusetts decisions, which are cited by my sister as well, suggest that in the Massachusetts courts, there's a growing recognition of the difference of impending youth and the like. My brother Justice does much better job of describing the actual topic than I do. But there's a growing trend within Massachusetts courts that says this should be in fact considered. And 68549 laid the precursor for that prior to the amendment of the regulations and said, the regulations really ought to take a look at whether or not the treatment of youth has in fact properly been represented by the regulations. And then the regulations were amended and nothing happened. Nothing changed whatsoever. And I understand that just because if my individual would have been classified as a youth, that it doesn't completely eliminate application of factor 2. However, I think when a hearing examiner uses their discretion and assigns the weight that should be assigned to each particular factor, they ought to take in consideration that what do we have here? We have a guy who's 1 month over age 18. He's under the influence of substances, and the offense that he committed, although egregious, is not as bad as many that we see in these cases. The defense that he knew.
The second defense is pretty bad.
There is no question about it. There is no question about it. But it was now, 20 years ago? It occurred in 1997. So it's 23 years ago that offense occurred. We have to look at what.
He behave himself in prison, though, did he?
Well, no, he didn't, but he didn't do bad either, to be perfectly honest with you. I mean, anybody under the nature of the offense that he has to deal with the institution, to go to MTC once and be bounced because of allegations which he disputed with regards to gang activity, and to find it within himself to go back and complete the treatment and then stay, although I know he stayed because his parole was granted, he didn't have housing, but nonetheless to stay and do so, there's a lot to be said for that. And the next question then, of course, is, well, is the decision sound? Is there substantial evidence in support of it? And my next argument, of course, is that the weight was afforded to the mitigating factors wasn't appropriate. To afford moderate weight to sex offender treatment, to somebody that completes treatment, to me is just egregious. I mean, this guy went through.
Well, but he's not, since release, he hasn't followed up. I understand there's a question of cost, but, once you start asking us, and obviously there are cases where it's clear, we don't see many of them, but there are, but to ask us that you don't like the way the hearing examiner weighed things, our deference is pretty broad.
There is no doubt about it. And I recognize that. I just think the number of cases that I've had, and I, as a member of the CPCS panel, I do many of them. I probably have 7, 8, 10 of them pending before your court presently. The number of people that I see that graduate from treatment at S2P are very slim.
I agree with that.
And then on top of it, the number that have the support system that this individual has, and for the hearing examiner to say, because his sister couldn't remember, I'm sorry, his aunt couldn't remember whether he was on probation or not, when because of that, and because his mother had boundary issues with regards to what she could speak with, that you should only afford moderate weight, most of these guys end up at Pine Street. He's not at Pine Street. So he has those advantages. Then the last thing I will say about that is this. He says, and there's no reason to contradict it, that first of all, the evidence supports that alcohol and substance abuse were a significant contributing factor in his conduct. Supposedly, and I want to believe my client, and the hearing examiner did as well, he's been sober for 20 years. And where did he land? He landed with a person who's also been sober for 20 years. And he has people looking after him in that capacity.
Is he participating in any sobriety program now?
Not to my knowledge, he is not, but his terms of probation only required sex offender treatment. And that's another interesting question for the court is, it does not say that it's discretionary on probation, and he's not been violated because the hearing examiner looked at his most recent query probably for that very question. And no one is suggesting this. I don't know much about sex offender treatment other than it's an intense program, but he participated in it for a very, very, very long time. And when you start looking at an excuse being the inability to afford it, that's a pretty valid excuse under our Constitution. And there's been no problems since he's been out, and he's in a good and secure setting.
It's a short time, though.
I don't disagree that he doesn't fall within the 5 years. I mean, there are things in this case that I wish there were present or otherwise, but there are enough things there for me to say, maybe the hearing examiner was a little arbitrary and capricious. Maybe there should have been a little more consideration given to his age and the nature of the offense before you apply unlimited weight to factor number 2. The rest of the factors that are risk aggravating and mitigating, other than public place, that's the only other thing I want to talk about with regards to the factors, and that's this. The impetuousness of youth has been recognized by our United States Supreme Court. Our courts and our hearing examiners certainly should take judicial notice of that. And to apply that factor when, in fact, the offense occurred in the situation as it did, it just screams of an individual impaired. And he came forward and apologized about it. He admitted guilt to both of these offenses. Listen, the second one is very, very troubling to me, but it was a very, very long time ago.
Well, I mean, I don't know what to say about, I don't know how this is going to come out. We haven't deliberated about this, of course, but I hope, regardless of how this comes out, that somebody presents in an appropriate case to a hearing examiner the full data about emergent adulthood and the relationship between that and this person had a long sentence. And so it's true that what we're considering are 20-year-old offenses. And under the case law, we're allowed to do that with someone who is incarcerated. Your sister cited a case that says that. But, you know, if someone could package this in a way that really teed it up for a hearing examiner, a superior court, our court, the SJC, to have a look at it. I don't think these are insubstantial questions. I just wonder whether merely taking judicial notice of the trend toward concern for emergent adults is the way to really get this squarely in front of the judiciary.
I totally agree with you. The only response I would have to say to you is this: 68549 clearly said to SORB, maybe you might want to take a look at this. And they amended their regulations and did absolutely nothing.
Well, you know,
it was teed up then, and they told them, and what did they do?
Well, that's a different branch of government. I don't know.
I really have nothing further.
Thank you.
Thank
Ms. Michaud. You have to unmute yourself.
Yeah.
Oh, I'm sorry.
Yeah.
You're set. You're set.
Nope.
Nope.
Wait, we can't hear you. That's odd. Wait.
Hold on.
Please.
We can't hear you. Brittany?
We can't hear Ms. Michaud.
Can you hear me now?
Yes.
Yes.
Okay.
All right. Okay, go ahead.
Good morning, Your Honors. May it please the court, Rachel Michaud for the board. So I won't belabor the facts, as it is very clear that Your Honors have read through the pleadings. But Mr. Doe, when he was 18 years old, committed a sexual offense against a stranger adult woman in public. He was arrested for that offense, and I will note that when he was arrested, he was found with a pair of women's panties in his front pocket. He was arrested for that offense. He was charged. He was in the community, and 6 months later, he committed an extremely violent rape against the second victim in this case. So I'd like to begin by addressing Mr. Doe's maturity argument. As stated in my brief, this issue should be deemed waived. He didn't raise it at the hearing with the hearing examiner. He didn't raise it even in Superior Court. His argument now is, for the first time, that because he was newly 18 years old, that he should be treated as a juvenile offender. I will note that the news.
Is his argument quite that extreme? I mean, there does seem to be some science around emerging adults. So in other words, you know, he definitely was a legal adult at age 18, but that the brain formation still is continuing up until 24 or 25 in at least young men, if not all young people. And that, you know, that we do know the SORB regulations do consider advanced age.
So I think that the appropriate response to that is that even if we were to, you know, consider him with a juvenile as a juvenile, or consider him, you know, with the research surrounding juvenile offenders, that factor 2 still applies, because not only did he commit multiple sex offenses over a period of time, but there was detection between. So he was arrested, he was charged, and actually while he was awaiting trial is when he committed his sexual offense against victim 2. And I think that in terms of the argument here, first I'll note that it's not a new study. What my brother is referring to as a new study is really an article published in 2017 with the section that he cites, citing studies from 1993 to 2010. And those studies talk solely about the criminal prosecution of 18 through 20-year-olds. But even just entertaining the argument of, you know, adolescent brain development, and that his sexual offenses surrounding around impulsivity, for example, I think that all of those, that idea is contradicted by the statements that he made in treatment. I'll note in the record that there's ample evidence that he offended for reasons other than just his youth. He talked about believing women like to be physically abused and sexualized by men. He admitted that the night that he raped victim 2.
When did he say this?
He admitted to this in treatment. The record appendix site is 211.
Well, when you say in treatment, do you mean a week after his arrest 20 years ago, or do you mean recently?
While he was in treatment at the Massachusetts Treatment Center during sex offender treatment is when he made these statements where he said that he believed that women like to be physically abused and sexualized by men, that he admitted to a historical thought pattern of using women as objects to serve a purpose for him.
Wait, an historical thought process? That is, he's completed sex offender treatment. I don't know what that entails, but I assume you're supposed to, among other things, take responsibility for your actions and recognize the, I guess, and this is just from what I've read in cases, you know, in briefing about these issues, that you have to recognize the whatever, you know, it's like cognitive behavioral therapy. You recognize the wrong way of thinking that you were having, or the mistaken understanding of things, to the extent that's what causes this. This is really beyond my skill set, but saying that he now understands what he did before is a little different than him saying, my current understanding is women want to be violently attacked, that would be quite dramatic.
Correct, but if you're looking at it as he was an adolescent and he committed his sex offenses because he was immature, I think that his statements in treatment certainly contradict the immaturity aspect of it, rather than something that was more deeply rooted.
Well, counsel, is it fair to say that one cannot successfully complete sex offender treatment if one has an attitude such as you just described?
So my understanding of completing sex offender treatment is that you complete it if you complete the objectives of the program. I don't think that it means that the treatment review panel or even the clinicians who refer the offender for completion doesn't have any concerns. I'll note to the record.
I guess, counsel, would you agree that it is fairly unusual for us to see someone, I mean, I haven't seen someone who fully completed sex offender treatment. Granted, these cases were shut off for a while they were being reconsidered, but it does not seem to be, certainly seems less likely than an atypical that they've completed this treatment, right? You're gone again.
Can you hear me?
Yes.
Okay, I'm sorry about that. My computer keeps randomly muting. So I don't think it's unusual for an offender to complete treatment, especially.
And what percentage of the cases that come here do you think they've completed the treatment?
Specifically for offenders who were sent to the Massachusetts Treatment Center, I think it's significant. I've only had one argument before. Is
that 20% or 80%, or do you have a?
Unfortunately, I don't have a percentage.
I guess do you have a concern that if you rely heavily on these statements, particularly without, for us, the context of when they were made, that you're discouraging people from completing this treatment?
Absolutely not. So I think that there's separate issues. So in terms of factor two's applicability, I think that here it applies whether he's an adult or a juvenile. But if we're talking about completion of treatment as a mitigating factor in front of the SORB, I think that offenders are strongly encouraged to complete treatment. But here, this particular offender, and this is kind of getting into my next argument regarding the substantial evidence, in the weight afforded by the hearing examiner to treatment, she afforded him moderate weight because of he didn't follow through with subsequent treatment. But he acknowledged in the record, I'll point to record appendix site 147, that says that he acknowledged that he needed to continue to gain insight, such as his risk areas of sexist coping and sexual preoccupation. And he needed to develop more of an awareness of those areas.
Is there evidence in the record that sex offender treatment post-release was available for him to go to?
So the evidence in the record, I'll point to, he sent a letter to the SORB saying that he was looking into treatment post-release, and that's at record appendix site 89. But then he didn't follow through. And I know in the transcript there was some argument where he first, he admitted that he wasn't being truthful with treatment providers when he said he was going to follow through. But then he kind of said, well, how am I supposed to afford that? Although there was no evidence in the record that he had even tried to get treatment, other than that one letter from him, or that the only thing barring him from obtaining this maintenance treatment or subsequent treatment was the cost. And if I could just make one more point regarding the maturity argument, and then I'll move on, is that he had a substantial problem adjusting to incarceration. And I'm talking, he was found to have made peepholes in the staff bathroom in 2009. And at that point, he was not a juvenile. He was 29 or 30 years old. And this is what resulted in his transfer to the Massachusetts Treatment Center. I know that he disputes it, but he was found guilty after a hearing, and there's ample evidence in the record to support that. Moreover, there were a couple incidences where he pleaded guilty to possessing pornography in prison, and that was also in 2009 when he was 29, 30 years old. So to sum it up, did the hearing examiner abuse her discretion in declining to consider his adolescent age? No, she didn't. She wasn't required to by the regulations. She considered him as an adult. Even if she were to consider him a juvenile offender, factor 2 would still be supported. Moreover, regarding the substantial evidence, factor 2 was one high risk factor. There were also 10 risk elevating factors present. He offended against 2 female strangers in a public place. He threatened to kill victim 2 and held a broken glass bottle to her neck. He has a history of illicit drug and alcohol abuse. He has a criminal history beginning as a juvenile. He had violent offenses as a juvenile. He was on probation. He was in DYS commitment. As an adult, he served time after violating probation for armed robbery. And then almost immediately after he got out, he committed his first sex offense. He poorly adjusted to incarceration, as I just mentioned. And there was some mitigation present, but the hearing examiner found that he was a level 3 offender. She properly applied the factors. She explained not only the evidence she relied on, but the weight she assigned, to the point where she applied increased or decreased weights. She explained her decision. There was no abuse of discretion. And if I could just, if there's no questions, I'll briefly move on to the internet publication portion.
Go ahead.
Thank you. So I won't belabor Doe 496501 because I know that all of your honors are very familiar with that case. This matter was decided 2 years prior to that decision, that prospectively held that hearing examiners need to make a separate and explicit finding regarding internet publication. There is some guidance to courts where the appeals are pending. Specifically, the courts can consider the efficacy of internet publication. And I'll point to a September case, Doe 23656, where they expanded upon that. And this is a very similar case. So Doe is a sexually violent offender. He was convicted of rape, which is defined by the legislature as a sexually violent offense at Chapter 6, Section 178C. He committed contact offenses, with the second offense being extremely violent against stranger women. These offenses were against strange women that he encountered on the street. I think that this is very similar to the court's finding in 23656, where public notification would inform those in his geographical area, particularly women in public, of his risks and presence, and enable them to take safety precautions. So this is a matter, the facts of this matter so clearly dictate he's a level 3.
These were adult women, all of them in that case. No vulnerable victims in the sense, I mean, obviously anyone is vulnerable to a broken bottle held to their neck. But
adult women, correct.
This is not a class of children or disabled victims or anything like that.
No, Your Honor, just strange women who were just out in public. And if there's no questions, the board will rest on its brief.
Seeing none, I'll thank you both. We'll take this under advisement.
Thank you, Your Honors.
All right, we are live.
Good morning. Welcome to the appeals court. I'm Justice Meade. With me are Justices Rubin and Henry. Each side will get 15 minutes. We're not going to entertain any rebuttal. With that, the case is 2019 P1441, MOUHAB RIZKALLAH versus Charles Baker and others. Mr. Rosen.
May it please the court, I represent Dr. RIZKALLAH. The dental director of Mass Health was putting down an insurrection. She had, or her agency had promulgated some illegal regulations, and the providers were unified in resisting them. There was only one facility in the entire state where a child could go to get continuation of care if the child left their original orthodontist. The leader of the revolution was, or rebellion, or was Dr. MOUHAB RIZKALLAH. He had sued Mass Health before regarding illegal regulations and had obtained a change in regulations, as happened in this case ultimately, as well. And he had also sued them, as I say, he sued them in this case. Dr. Dr. Jones had no basis to believe that Dr. Riscallah had violated any regulations, and this is important. The regulations don't say that you have to accept every patient that comes to you. It says that you have to treat mass health patients the same way that you treat any other private pay patient, and there's no evidence.
Including transfers, right?
Including transfers, and there's no evidence that Dr. Riscallah was accepting any transfer cases. In fact, the verified complaint says at paragraph 43 that Dr. Riscallah has stopped accepting any transfer cases. So Dr. Jones had no basis to believe that he was violating the discrimination regulation. But nevertheless,
But doesn't that violate the Medicaid rules? And
Yeah.
he told Dr. Jones that the fee was too low, and that's why he wasn't accepting them.
well, that's another that's something that you're asked to assume, and we have a motion based on that. We don't know what he told Dr. Jones because his email to Dr. Jones is not in evidence.
Okay, so this is, and I'll ask your brother too, this seems like the critical question. It's a motion to dismiss. We take the allegations in the complaint as true. The allegations in the complaint are he filed suit, and then a couple months later, he gets this threatening email.
Right.
And leaving to one side, is it enough of a threat? And what does a reasonably firm person do? You know, assuming all of that is met, the email on which you rely in the complaint, which is attached, has a couple paragraphs that appear to be quite broad about what he has to do. And then there's a couple sentences at the end that say, with respect to the patient you emailed me about wanting a different referral or whatever, and it says something about that. Somewhere, someone, I don't know if it was the defendant or the judge, has reached the conclusion that that entire email was a response to something that your client sent and not a response to the lawsuit. And it includes something about, I don't know where this comes from, there are over 200 people I haven't taken or whatever. What are we supposed to do with that? You're talking about questions of is it violate a regulation or not? That's all fine and good. I'm trying to figure out, given the posture of this as a motion to dismiss, what are we supposed to think, if anything, about what triggered that email from Ms. Jones?
I think you need a fully developed factual record to make any conclusion about that, and you don't have it. And that's why this case should not have been dismissed. There should have been discovery. We don't know what the factual predicate was. We know, we don't, what was this a response to a single email? Well, just reading the email itself, it doesn't seem that it was, because she's telling him, you have to, I'm not looking at the email, but something like, you have to discontinue this policy or practice. And if you don't, then you have two choices. Either you can stop accepting mass health patients altogether, in which case he's a Medicaid orthodontist, he has no patients, or you have to provide us with a written recantation that you have ended this policy or practice. She's not talking about a single patient. So
she doesn't mention, Mr. Rosen, she doesn't mention anywhere in the email any sort of criticism of his public statements, and she doesn't mention the lawsuit either.
No, she doesn't. But she clearly knows that she's being sued because she's named in the complaint, and the allegation as in the complaint, which I think you have to take as true in all permissible inferences, and certainly a permissible inference. In fact, it's our whole case that this email was this singling out of one out of hundreds of doctors.
Counsel, I understand we don't have whatever your client sent, but the document itself, which I believe is in the appendix at page 66, says right at the top in two different places that it's a reply to an inquiry from him.
That's right.
So you're telling us we should just disregard that for purposes of deciding this case?
Well, she said she is clearly replying to an email of his, and in that reply, she makes an unwarranted threat. And we don't know what the email said. If the email said, for example, what the complaint said, which is you have promulgated illegal regulations that make it impossible for these children to get treated, and I have sued you as a result, or even if it didn't say that, if that's the factual context, well, that there's your link, but you don't have it because this was dismissed.
But there was no action was taken against him, no adverse action, right? He continued to be a provider.
Well, it depends what you think an adverse action is.
Was he sanctioned?
No, he was not.
Was he punished in any way?
He was not punished, but the MCRA doesn't say that you have to carry out your threat. It talks about threats, intimidation, and coercion. A threat is enough. There's no.
Are you claiming under both the federal statute and the state statute?
The federal statute requires interference. I don't think the federal statute 1983 mentions threats. I think that it. I don't have the text of 1983 in front of me. I'm home. But,
well, are you challenging the dismissal of that?
Am I challenging the dismissal of the 1983 claim?
You're only focused on the state statute, right?
Right.
Well, wait, so you're not appealing the dismissal of the
no, we're appealing both, and I do not have the text of I think 1983 says interferes or attempts to interfere, but I may be.
Yeah, but Mr. Rosen, if Dr. Jones was using a lawful means to quote unquote threaten him, that's not actionable under the State Civil Rights Act.
Sure it is. You can act under color of law and
not if you're acting lawfully.
Well, that's the question, isn't it? Was she acting lawfully?
Well, it's all in the regulations for Medicaid.
Well, if she had no basis to believe that he was violating any law, but she threatened him with sanctions anyway.
Well, it's a little trickier than that. I thought your position was that even if in general, the director of dental services can tell people they have to follow the regulations such as they are, that your client was singled out when she knew lots of people were, maybe everyone except Children's Hospital was not taking any of these patients, but your client gets this threat. I thought that was your argument here, so that even if it's lawful in general, it's not lawful when done as a retaliation for First Amendment conduct.
Yes, that's exactly right. Thank you, Your Honor. But in addition to that, if she had no reasonable basis to make the claim in the first place, that just compounds it. But you're absolutely right. If what he was doing was illegal, then she was wrong to single him out.
I certainly understand that you have the right to craft your complaint the way you want to craft your complaint, but it does seem where you know that, and he should have the email he sent. Why, and courts really dislike piecemeal litigation because we have enough work without seeing cases in teeny tiny pieces. Why should we let this go forward where we know you've withheld something? Why shouldn't we, as a matter of policy, say, you know, certainly the defendant can come on and bring a summary judgment motion, but where you know that your guy sent an email, I mean, I take it we are to assume you complied with your Rule 11 obligations, because if this email says something otherwise, then it seems like you have a different problem. But it is a little frustrating that we know you know the full story, and we know you've made a deliberate choice not to share it with us.
Well, actually, Your Honor, that's not true. I've never seen the email. I received the threat, and that was enough for me to file it.
Why does your client not have possession, custody, and control of the emails he sent?
I'm sure he does. I'm sure he does. I'm just telling you, I haven't seen it. I did not make a deliberate choice not to include it. When I was filing the civil rights complaint, the email was what I was concerned with. I could have included, there may have been a whole email chain. I just don't know.
is there a mechanism short of summary judgment that would have allowed your brother to put it in at the motion to dismiss stage? Because presumably Ms. Jones also has copies of these emails.
I don't know.
I'll ask him.
Okay. Could he have put it in? I think you're limited to the complaint, but
I think it would convert it to summary judgment if he put it
Probably
in.
if you attached it.
but it could have been treated as a motion for summary judgment had they put in that piece of paper. And if that piece of paper were dispositive, I mean, they could have done it at the same time. It would just sort of been treated, as you said, Judge, as a motion for summary judgment. The point is that singling out a provider who is the leader of a rebellion or an insurrection against illegal regulations and threatening him when they didn't threaten anyone else with no legal basis to do so is the kind of heavy-handed use of the police powers and economic coercion that constitutes threats, coercion, threats and intimidation that would have the natural effect, I think is the language in the cases, of to coerce the plaintiff in the exercise of his rights.
Can I ask Mr. Rosen a question about qualified immunity? Can you tell me where it's clearly established that a Medicaid provider has a First Amendment right to refuse to treat patients simply because the fee is too low?
There is no First Amendment right of a Medicaid provider to treat patients because, you don't have to.
There's no clearly established right in play here.
Oh, no. The rights that we're talking about aren't those rights. We're talking about the right of access.
Tell me what right is then that's clearly established.
Yes, we're talking about the right of access to the courts and the right of free speech. We're saying that this action.
Don't we have to apply them to these circumstances?
Yes.
And so his access claim relates to him refusing to treat people because of the fee being too low.
No, the claim has to do with him saying that these are illegal regulations and that no dentist can treat people because of these illegal regulations, because it just makes it economically impossible for dentists.
All right, then what's the case that you're relying on that makes this clear?
Well, I mean, I've cited the Snodgrass King case in which a motion to dismiss was denied on very, very similar facts to this, where a dentist was critical of DentaQuest, which is the same organization that runs our dental program, and they retaliated against him.
And wasn't he excluded from the program?
He was ultimately excluded from the program.
And your client has not been excluded.
That's true, but you don't have to take the action. All you have to do under the MCRA, or I think even under.
Why couldn't a reasonable person in Dr. Jones' place believe that as long as she didn't exclude him, that she wasn't violating any clearly established law, even if Snodgrass establishes anything clearly?
Depends on the factual predicate.
That's what I was going for. The factual predicate is different.
Well, you don't have to carry out your threat in order to intimidate or coerce someone in the exercise of civil rights. There are no cases that say that I've seen.
Okay, thank you very much. Mr. Martland.
Good morning, Your Honors. May it please the court, Douglas Martland, Assistant Attorney General for the state defendants. A provider told MassHealth that he was engaging in conduct not permitted under MassHealth regulations. That conduct was causing harm to a patient, and a MassHealth regulator told him to stop. Her message didn't violate the provider's civil rights, and the implausible allegations in paragraphs 54 through 57 of the second amended complaint don't establish otherwise.
Oh, counsel, I don't I don't think any of that is in dispute, but his central argument seems to be that a lot of people, pretty much everybody was doing this, but it was only this one person who was singled out and treated differently. So what's your response to that?
Two responses, Your Honor. The first is that he's creating a false equivalency here. Paragraphs 54 through 57 of the complaint don't establish that any other orthodontist wrote to Mass Health and advised that they wouldn't be treating a particular patient because of the sufficiency of the rate. And second, those same allegations in paragraphs 54 through 57 of the complaint don't include the critical email that Dr. Jones was responding to, and where that email, or where her email demonstrates that she was responding to an email that he's not even alleging and not even focusing on in the complaint, we have a reasonable basis to conclude that she was responding to that email and not responding to his last.
Okay, so this is the, I'm sorry, go ahead, Judge.
Well, his response is going to be that we are, and he's got some pretty good case law on his side, that we are bound by the complaint and construing all of, taking the allegations as true and construing, giving all inferences in his favor, and that he has in fact alleged that he was the only one who got this letter. So why can we disregard those allegations? I mean, am I right that you're asking us to disregard those allegations?
No, Your Honor, we're asking you to look at all of the evidence in the complaint, which includes the email that the regulator sent to the provider. That email, when you read the plain text of it, shows that the allegations, the 4 paragraphs of allegations in the complaint alleging 2 civil rights violations, are implausible. They ignore the critical fact, or they omit the critical factual basis for the email that the regulator sent to the provider. And on that basis, the court can conclude that the allegations in the complaint are implausible and don't.
Well, how can we, I mean, certainly stranger things have happened than a government agency threatening the person who sued them, right? I mean, that, unfortunately, that does happen. You say it's implausible because he failed to include the initial email? I'm just trying to sort out, because we have to draw every inference in favor of the non-movement here. And I don't think that drawing every inference in favor of the non-movement, those first paragraphs are necessarily a response to the previous email. But I agree with you, he didn't put in the previous email. Of course, you didn't either, although that would have converted things to summary judgment. I assume you have it. And if it is, as you say, I would think that you might both quickly get summary judgment in this case and also maybe get some kind of sanction for a misleading complaint. But how are we supposed to, do you have a case that says when we infer that something has been left out that we need to know, that we should dismiss, something like that?
Your Honor, we cite 2 cases in the opposition to our motion to strike, one from the Sixth Circuit, and I believe one from the SJC as well, which explain that the court doesn't have to accept inferences merely when they're consistent with an entitlement to relief. Those allegations in the complaint need to be plausible. And here the allegations, given the critical omission of the email in the exhibit that contradicts the entire causation theory that's set forth in these bare bones allegations, establish that they don't have a plausible entitlement to relief. And that's the focus of our motion to dismiss. That and the separate grounds, which Judge Meade mentioned earlier, that the dental director is entitled to qualified immunity in these circumstances. 1, because her conduct didn't violate any clearly established right, and 2, because no reasonable person that would assume that a regulator sending an email to a regulated party that said stop doing impermissible conduct would violate somebody's civil rights, even where there was an ongoing lawsuit.
Well, I guess, I mean, look, there's 2, you pack 2 things together. Let's take the qualified immunity first. it sort of depends how you frame the question. Presumably, it's clearly established that you can't threaten someone in response to their filing a lawsuit. Now, that's a question of subjective intent, I guess. Why isn't that adequate to defeat a claim of qualified immunity?
And I think it's very important you're here, Your Honor, to point out that the existence of a lawsuit doesn't shield a provider from complying with agency regulation.
I agree with that, but I'm talking about an intentional decision. You know there's a problem with the regulation. No one is following it because they'd go out of business. So you can't get your patients treated. You're the head of dental, you know that. A lawsuit is filed and you decide, again, leaving aside which I do want to get back to, the question of the initial email. You decide, I'm going to threaten this guy. Either it'll get him to back down, or if it doesn't, nobody else is going to sue us because they know that we're going to threaten their livelihood, right? What would that be subject to qualified immunity? If that happened, I'm not saying it did, but if that happened.
I can see a world, Your Honor, where the hypothetical that you're presenting has some validity, but it's not the facts of this particular case. It certainly doesn't meet the bare bones allegations, and it doesn't conform with the procedural history of this case. At the time the email was sent here on August 21st, 2017, the lawsuit that that the provider had filed, or his organization had filed, as well as some member children, the PI motion that he had filed had been denied by the Superior Court, and the provider had represented to the court that he was going to amend his complaint to adjust the case to the existing facts. So in that context, it's a very different factual scenario than the one that you're concerned about. I'd also like to mention, Your Honor, the context in which the second amended complaint was filed. It was filed in, I believe, October 2018, over 13 months after the dental director here had sent the email to Dr. Rizkallah. It focuses entirely on her email. It doesn't allege any adverse action that MassHealth had taken in that 13 months, including after the September 1st, 2017 deadline that's set in the dental director's email. The provider here remained a member of the MassHealth program, was continuing his conduct. And in fact, MassHealth had changed the regulations back to the regulations that were in place before his lawsuit was filed. So essentially, he'd gotten everything that he wanted, and there was no adverse action taken against him. And I think on those facts, which are established at the time of the complaint from the procedural history in this case, we can conclude that nothing had deterred him from his course of conduct.
Can I ask you about the motion to strike?
Yes.
You describe his email, right?
Yes.
You describe what you say he sent. Is it anywhere in the record, or is that based on extra record knowledge or inferences? Where do you get this stuff about what his email said?
I think it's reasonable here, looking at the text of the email, including the statements that the dental director makes in her statement. The top line of the email refers to it as a reply to a MassHealth member inquiry. She also refers to, in the final paragraph of the email, regarding the patient that the original inquiry was about, that we can conclude that what the text of Dr. Rizkallah's email to her was about.
So, but I thought that, maybe I'm misremembering this, obviously we have a lot of cases, but I thought that you described it as actually saying, I have turned away over 200 patients or something like that.
That particular fact, Your Honor, is not, as far as is not established in the dental director's email here. But where it is established is in the court filings that Dr. Rizkallah made, and it is including the allegations of the complaint.
Wait, I understand the fact of what he did, but you said, I thought, maybe I'm mistaken, in the Commonwealth's brief, doesn't it say that that's what his email to her said?
That was certainly not our intention to represent that, Your Honor.
Okay, so you don't have any information in the record about what the email was exactly?
The original message that the provider sent to Mass Health is not in the record. Of what we can conclude from the record, we are taking from the dental director's email
Yeah,
response to
but
him.
that's tricky, right? I mean, we all have email chains that say at the top, you know, re-lunch next Thursday. But by the time you're on your 12th email, you may be having a fight about something totally different. You know, I don't think the header gets us all the way home.
Well, again, also the final paragraph of the email refers to the original.
I agree, but
about
that's
another.
about one patient. It's not about a pattern or policy. Now, he may have written about a pattern or policy. I'm just having a hard time sorting out what's supposed to happen here. He has left out an opening email. Maybe when we see it finally, and maybe you have seen it, he says he hasn't. Each of your clients has it, I would think, or could retrieve it in any event. So we don't know what it says. It may say nothing, right? It may say Billy Smith is a kid who needs a referral. Or it may say, dear Dr. Jones, you're an incompetent nincompoop. And as a result of your failures, I've stopped seeing patients and refused to see them. And right, I mean, we don't know.
And Your Honor, I think that comes back to the plausibility of his allegations. He has the obligation here to set forth all of the critical facts in his complaint. And here, when you look at the complaint, there are 4 paragraphs, paragraphs 54 through 57, that contain bare bones allegations that don't state a plausible entitlement to relief when you compare them with the actual exhibits in the complaint. If there are no further questions, we'd ask this court to affirm the Superior Court's dismissal of the civil rights case claims and enter judgment for the defendant. Thank you.
Thank you very much. We'll take this under advisement.
All right, we are live streaming.
Welcome to the Appeals Court. I'm Justice Meade. Sitting with me today are Justices Rubin and Justice Henry. Each side will be given 15 minutes. This is being recorded and live streamed on YouTube, on our YouTube channel. There's a clock that'll be in the upper left corner, so you'll know when you're where you are in the 15-minute clock. With that, call the case 2019 P 1443 MOURA HEALEY versus Health Plan Intermediaries Holding. Mr. Sweeney.
Good morning, Your Honors, and may it please the court. My name is Doug Sweeney, and with me are Allison O'Neill and Brian Devine, and we appear on behalf of the appellant, Health Plan Intermediaries Holding, LLC, which I'll refer to as HII. I plan to proceed to a discussion on the merits of this appeal, but I'm happy to answer any questions the panel might have in regards to the Attorney General's motion to dismiss.
I don't understand how your notice of appeal is timely. I'll cut right to the chase. It was filed 75 days after the order at issue, and you filed a motion to reconsider within 30 days, which is not a Rule 59 motion or the equivalent that needs to be filed within 10 days. You rely on criminal cases, which correctly have a 30-day limit on them, but you cite nothing in your reply. Cite no case law in your reply that explains why this appeal is timely.
Your Honor, HII's appeal is timely for 2 separate and independent reasons. First, because a single justice stayed all appellate proceedings, which extended the deadline to file the notice of appeal.
Forgive me for interrupting you there, but there was no appeal at that point. There was a single justice petition, so there were no appellate proceedings to be stayed.
Except the appellate justice petition, right? The single justice petition.
But the single justice did not have jurisdiction, Mr. Sweeney.
Oh, well, Your Honor, the Rule of Appellate Procedure 2 allows a single justice of the appeals court to alter or suspend any rules on its own motion. And I believe its order to stay appellate proceedings, it was doing that. The second reason.
Okay, I'm sorry, go ahead.
If you have any further
You,
questions.
you don't have any case law, though, that says that this forgives a late notice of appeal.
No, Your Honor, but I believe the plain language of the rule gives the single justice authority to so suspend.
The single justice has all kinds of authority, including under Rule 14, but he didn't exercise that either, and nor was he requested to.
You're right, Your Honor, but again, Rule 2 may be exercised on the court's own motion. And I believe that's the plain language of the order says appellate proceedings are stayed, which stayed the notice of appeal.
But I don't want to repeat myself, but there were no appellate proceedings at that point. What he was staying was any further action in the trial court, I believe.
Well, respectfully, Your Honor, it says appellate proceedings are stayed. So
and I agree, and I'm telling you, it's a misnomer.
Respectfully, Your Honor, I would disagree with that. Okay. It says appellate proceedings and not proceedings in the court below, which obviously the single justice also had authority to do that.
But why doesn't that simply refer to what you had before the single justice? That's an appellate proceeding. That's the only appellate proceeding then pending. And then it's stayed so you could seek reconsideration below. I mean, why isn't that sort of the end of it?
Well, I think the motion says appellate proceedings. It does not cabin itself to the petition or to any other issue. And by just saying appellate proceedings, I believe it stayed the notice of appeal deadline. And if I may kind of turn to the second point regarding the motion for reconsideration, is that a timely brought motion for reconsideration stays the notice of appeal deadline. And the source of this tolling doctrine is not a statute or the rules of appellate procedure, as the Attorney General contends, but is a common law rule rooted in practicality and efficiency and recognized by this court in Powers and Lewis.
But the key part of what you read to us is timely. And you did not file it within 10 days, which is what Rule 59 requires.
Well, Your Honor, the motion for reconsideration was not a Rule 59 or a Rule 60 motion. And this court in the Curley Customs case recognized the difference between a Rule 59 and Rule 60 motion and a motion for reconsideration. A motion for reconsideration is not found in the rules. Curley Customs and I believe the Selby case also say that. Instead, it's based on the inherent authority of the court to reconsider its order. And further, our motion for reconsideration could not have been a Rule 59 or Rule 60 motion because there was no separate judgment entered under Rule 58. We asked the lower court to—
I'm sorry, well, the June 26th order was appealable as final.
Yes, Your Honor, but it wasn't a judgment.
Well, you may have a different problem if you don't have a judgment in this case.
Perhaps, Your Honor, but plainly, the Curley Customs case explicitly—
I'm sorry, is that in your brief, Curley Customs?
Yes, it is, Your Honor, and that goes to the sort of nullification of a notice of appeal issue under Rule 4A3. And in the Curley Customs case, the court ruled, so typically a Rule 59 or Rule 60 motion will nullify a notice of appeal that's filed before a Rule 59 or Rule 60 motion is decided. The Curley Customs case held that a motion for reconsideration filed after a notice of appeal had been filed did not have the nullification effects that a Rule 59 or Rule 60 motion had on the notice of appeal. It recognized that a notice for reconsideration is a distinct vehicle from a Rule 59 or 60 motion. And then this court in Powers explicitly said that a motion for reconsideration is premised on not a statute, it's not expressly authorized by anything, but it's a long-standing principle that applies in both civil and criminal cases. And it's rooted in practicality and efficiency, And the concerns in both criminal and civil cases are the same, is that it would make no sense for litigants to take recourse to the appeals court if the trial judge will reconsider the decision and grant the relief that they seek. If I may.
Can we turn to the merits maybe for?
Yes, thank you, Your Honor. This case began nearly 4 years ago when the Attorney General issued a pair of civil investigative demands on HII. Over these past 4 years, HII has produced 2,300 documents totaling 55,000 pages of information and has further sat for 16 hours of testimony over the course of 3 days.
Okay, but you didn't provide everything they asked for. The affidavit doesn't say you did. Maybe I'm parsing it too fine, but it doesn't use the ordinary language of saying that all responsive documents, to the best of his knowledge, have been turned over. Knowledge have been turned over. You point out that there's a couple of things where the government has said, look, yeah, you don't have anything on that, but there's lots of other things. You send some guy up, he knows what the questions are. He comes back down to Florida, deliberately fails to ask anyone what the answers are, comes back for another deposition. I don't really see, and you're fined $5,000, it's disproportionate. But if the top is $5,000, I can imagine people with all different kinds of failures to comply getting the top fine. Where's the error here, really?
Well, Your Honor, I would respectfully disagree with your character.
With everything I've said.
That the affidavit of compliance did satisfy the document CID, and the court the lower court explicitly did not recognize that affidavit of compliance. It did not say the affidavit of compliance is inadequate because XYZ. It said HII had not produced an affidavit of compliance. I believe that's a material error of fact.
So counsel, where in the record is this document certification that you say was filed before the Superior Court entered its order? What page is that?
It's page 150 of the record appendix, Your Honor.
Okay.
And it states, it is my good faith belief and understanding, based on my review of the materials produced to date, that HII's document production is now full and complete. And the Attorney General attempts to parse this to the point of absurdity, saying that, oh, this means the affiant only reviewed the documents.
But it says based on reviewing what's been turned over. It doesn't say I've spoken to the CEO and the chief financial officer and whoever else and have been assured that every responsive document has been turned over. How can a person tell from looking at what's been turned over that it's everything in the file?
Your Honor, the document CID did not require a listing of who the person spoke to. It required a sworn statement saying that the document production was full and complete. And thereby using the term, my review of the documents that had been produced, that clearly means that the affiant had reviewed them to ensure that all responsive documents in HII's possession were among the documents that had been produced. And I don't think reading into the lower court's decision that, oh, we didn't use certain magic words comports with the actual decision. And if I could just turn to the civil penalty issue briefly, is that I believe the court made an error of law when it imposed a novel in the Commonwealth constructive non-appearance interpretation of Chapter 93, Section 7. The language of that statute says someone who fails to appear is subject to penalties. The HII could not find a single case applying Massachusetts law that allowed for a constructive non-appearance penalty under Section 7.
But when we look at some of the case law from other jurisdictions, now this obviously this is an argument we'll have to, if we reach the merits, we'll have to figure out. but it's not unprecedented for courts with a failure to appear rule to include deliberate failure to prepare so that you can't answer the questions. I'm not saying it's a uniform nationwide rule, but some circuits have adopted under Rule 37, federal circuits. So, I mean, we're going to have to figure out what it means, I guess.
Certainly, Your Honor, and I agree with you on that. But those cases from other jurisdictions are so vastly different factually. I believe it was the Fifth Circuit in the Resolution Trust case said the person literally showed up and was not able to answer a single question. And that's consistent throughout all of the other cases cited by the Attorney General and ourselves in the brief, is that these were people who were unable to answer any question in an intelligible manner.
So what is supposed to happen? A person comes for a deposition and they're asked a bunch of questions they say they don't know the answer to. And so everyone agrees, all right, well, you go back home, you figure out what's what, we'll have a second deposition later. The person goes back and deliberately doesn't ask anyone in the company for the answers to the questions, presumably because he doesn't want to respond to them in the deposition. He flies back up, sits down. Apparently it's worth it to the company to fly him back and forth and probably put him in a hotel, more than losing this case, I guess. And so he sits down and they say, well, okay, so now what is the answer to why you terminated this relationship? Oh, I don't know. Did you ask anybody when you went back? No, that would have been foolish. I didn't. What's supposed to happen?
Well, Your Honor, no deposition is perfect where the person's going to be able to answer every single question. And I recognize that there may have been some non-perfect deposition deposing there, but the fact is that the deponents were able to answer a significant number of the Attorney General's questions. They sat for 16 hours of testimony. Presumably, if you go through the transcripts, which I'm not saying the court needs to do, but by the very fact that the Attorney General deposed these deponents for 16 hours shows that some information was going out.
Okay, but what sanction is appropriate? Should judgment be entered for the Attorney General? That is, I understand you don't want to pay a $5,000 civil fine. What is the appropriate penalty if the judge finds, well, they need this information and it's not being provided?
Well, I believe the order of operations is to get an order to compel, and then if there's non-compliance with that order is when sanctions are appropriate. And that's the lower court jumped the gun there. I see that I'm out of time, but HII respectfully requests that this court vacate the lower court's order and also the civil penalty imposed by it. Thank you.
Mr. Maslin.
Thank you, Your Honor. Good morning, Your Honors. Emiliano Maslin, Assistant Attorney General for Petitioner Appellate Attorney General. So to go first to the issue of timeliness, there are a couple points I'd like to make. The first is the argument about the order actually made by the single justice, and the plain language of the order, which is in the docket entry on, I believe, Record Appendix 249, says, Ray number 1, appellate proceedings stayed, and number 1 was the single justice petition. So this is exactly the Justice Rubin's question, what the single justice stayed was the single justice petition. And that's not surprising because this is not in the record, but if the court wished to look at it, it's obviously in the docket and the single justice petition itself. The petition asked for the petition to be stayed. So that's what the single justice acted on. That's what the single justice stayed. And the plain language of the order confirms that it's about the staying of the petition and not all appellate proceedings or any other appellate proceedings, such as the filing of a notice of appeal in a plenary proceeding. The second issue is about the suggestion that there's some free-floating common law doctrine that you can motion for reconsideration irrespective of Rule 4A, allows an appeal to be timely if it's made. So the first issue is that the language of the rule, as more recently changed, for example, than Curley Customs, makes clear that motions under Rule 59 or 60B, however titled, do stay the running or reset the clock, but only if they're filed within 10 days.
So can I take you back to that docket sheet? 'Cause
Yes,
I'm
sure.
looking at it now.
Yes, John.
If I look at the, there's a memorandum filed. Number one is the petition itself. I assume the petition itself didn't ask for a stay.
It did, I'm sorry, it did.
The petition asks for a stay.
Yes, the language of it is, it said that.
Do we have, we have obviously the records of the single justice case at the court, but do we have that petition in the record so I can see what the nature of the stay that was sought was, so I can maybe see what was granted?
Unfortunately, Your Honor, the petition is not in the appendices before the court.
But you're telling me that if I look, obviously we can take judicial notice of these things. If I look in the case folder for this case, in the single justice case, I will see exactly what it was they asked for. And I can then understand what was allowed.
Yes, Your Honor, I believe it's on page 4, and I believe it says HII assents to a stay of this petition pending the lower court's resolution on the motion for reconsideration if the single justice believes it would be helpful to the ultimate resolution of this matter.
So that's what HII said. So you think HII specifically asked for a stay of this petition?
Yes, Your Honor.
All right, now let me ask you this. Let's say it's a little ambiguous. Let's say stay of appellate proceedings is a little ambiguous. Does that mean we don't have to do anything else until this motion for reconsideration? Have you stayed every possible appellate proceeding that we might contemplate? Should we exercise whatever discretion we have to hear the merits of this because of the possible confusion about that? Because if it stayed everything, and if someone understood, well, we just asked for this petition, but it says appellate proceedings are stayed. So don't bother, Herb, don't send in the notice of appeal. We don't need to yet. The 60 days is told.
Well, I would say two things, Your Honor. One is, to the extent the court's question is about the court's power, of course, the court has the power to hear it. So it's not, I'm not gainsaying the court's power to hear, but just in terms of the suggestion that there's somehow legitimate confusion about the meaning of the order, they ask for a stay of the petition, and then the single justice enters this entry on the docket that says Ray number 1, appellate proceedings stayed. I don't think there's a reasonable way to be confused about what that means, and that it somehow extends beyond the single justice proceeding to a notice of appeal in a plenary proceeding. If there aren't further questions about the timeliness.
Do you have any thoughts on the Curley Customs case? Because I just read it, and I don't believe it helps the defendant.
Well, in short, I agree with Your Honor. I don't want to belabor it. I think that the main point, or I'd make 2 points, but the main point is that Curley Customs talks about the express language of the rule, and the rule's been changed since Curley Customs. The language referring to Rule 59 or 60B, however titled, is after Curley Customs. And I think
procedurally, though, it's different as well, because there a notice of appeal had been filed, and then a motion to reconsider was filed, which, had it been a Rule 59 motion, would have required a second notice of appeal to be filed. So it has no bearing on this case.
I believe that's correct, Your Honor. And there, even prior to the rule, and the reporter's notes to the change in the rule suggest that it was meant to avoid confusion or eliminate confusion about how to deal with motions for reconsideration, more in the positive sense of when they could possibly give additional time.
Please go ahead with the merits. I'm sorry to take up so much time.
Oh, not at all, Your Honor. I thank you for the question. So a few points that I'd make. The first is that the court correctly found that HPIH or HII, however denominated, the appellant here, had not provided an affidavit reciting that all responsive documents had been produced.
But it says that it's his good faith belief that discovery is complete. Well, how can it be complete without producing everything? I understand that he may have looked at the wrong thing or asserted that he looked at the wrong thing or whatever, but he says it's complete. Now, I mean, I don't know what the sanction is. I mean, obviously a perjury prosecution ultimately, but if in fact that's just, you know, if he later came into court and said, but judge, I deliberately wrote it this way because I have no idea if everything responsive has been put in, maybe he could be sanctioned. You know what I mean? I mean, there aren't exactly magic words. I don't like the way it's written myself, as I suggested, I think before, but.
Well, I guess what I would say, the couple things I'd say, Your Honor. The first is that it's about matching up of what their contention was to the affidavit. If you look at the order, which I'm sure Your Honor has, the trial court found that it said HII, I think it said HPIH, is asserting that it's produced all responsive documents. And then in the next sentence, it says, in effect, it hasn't produced an affidavit that says it's produced all responsive documents. So the court found that the assertion they were making, which is that we're totally done, wasn't matched up by the affidavit, and that the, for lack of a term, sort of equivocal language in the affidavit, as Your Honor, you know, recited in the question earlier, the sort of reference only to the documents that have been reviewed and not, you know, all the documents that they have, or having looked at all sources of information as the full scope of documents that they have, and the language full and complete, not matching up to the assertion in opposition to the petition and in support of their motion. And that's the key thing here, is that the affidavit was insufficient to eliminate the serious concerns that they hadn't fully produced. It was an equivocal affidavit, and on the record, there were serious concerns that there were documents that were outstanding that they hadn't produced. And given that there's a heavy burden on the CID recipient to avoid being required to fully comply, in that context, the affidavit was insufficient.
How are we supposed to decide the legal question whether constructive non-appearance is something that we should find to be sanctionable under this rule? Some courts say one thing, some say another, not under this statute, obviously, but similar language.
Certainly, Your Honor. Well, I think one can start with the principle articulated back in Yankee Milk, repeated by this court in Harmon law offices, that the statute is to be liberally construed in favor of the government. And if there's a question about how to construe this portion of the statute, whether constructive non-appearance is an appropriate basis for sanction, I think that one should start with that principle.
Can one be criminally liable for violation of this?
Violation of an order, of the order, for example, is subject to contempt. And so I pose this potentially criminal.
I'm just thinking as a matter of lenity, do we have to apply any of these kinds of doctrines? Because sometimes something with a civil component can also be the basis of a criminal prosecution. And, you know, I don't know.
I wouldn't think that principle would apply here, Your Honor. I mean, this is a civil penalty. It's in the context, for example, of the amounts at issue in this case, where consumers paid millions of dollars. A $5,000 penalty is a very small amount of money to be at issue, and in terms of thinking about the purpose of the statute, the Attorney General has broad investigatory authority. And if you have entities such as the entity here that serially comes back, failing to prepare, failing to provide the information, delaying and frustrating law enforcement investigation here into its misconduct, a $5,000 penalty, it seems to me entirely appropriate, given the what the court gave something referred to as an egregious example of one particular instance of this conduct. And egregious non-compliance, which is what we had here, is appropriately subject to a severe penalty within the range that's available. The sufficiency of the severity of this to bring them to heel is apparently, it may not have been enough, but it at least was it was appropriate for the court to sanction in this way, pursuant to the statute. And the one additional point I'd make, the two additional points, Your Honor. One is there's a suggestion that the only cases out there are of effectively complete inability to testify, and that's not accurate. I advert to the court to the, for example, the Pioneer Drive case, which is cited in the papers, where there's a discussion of significant non-compliance, but the facts are not as stark as in the Resolution Trust situation, for example. It's also, of course, of interest that Justice Laureate's opinion in the Short v. Hogan case, where there was extreme non-compliance by one designee, but there's not even a discussion of consequences flowing from it. Here, the court has made findings on both. Not only was there significant failure to prepare, but as the court found, it resulted in some instances, the inability to answer appropriate questions. And the other point that I'd make in response, something that was raised, is the suggestion that the order of operations were wrong. And that's simply incorrect under the statute. The statute, it's different than or it's actually, in this way, it's parallel to the civil rules, which is that a failure to appear can itself be sanctioned without there being an order. And this statute mirrors that part of the civil rules, where the types of violations that are articulated in it, amongst them being failure to appear, are subject to sanction. Not if there's a predicate order, but they're subject to sanction right away. If there's a violation of that order, pursuant to Section 7, it's then subject to penalties as contempt. If there are no additional questions from Your Honors, I'll rest on all other issues on the briefs and ask this court to dismiss the appeal as untimely brought, or in the alternative, affirm the Superior Court's order. Thank you, Your Honors.
Thank you. Thank you all. We'll take this under advisement.
Okay, we are live streaming.
Good morning. Welcome to the Appeals Court. I am Justice Meade. Sitting with me are Justices Rubin and Henry. Each side will be given 15 minutes to argue. This is being broadcast live on our YouTube channel. There'll be a clock in the corner indicating the time that you have left to argue. With that, I'm going to call 2019 P 675 Smich versus Mission 4 Incorporated. Mr. Peerboom.
Good morning. I'm Wayne Peerboom. May it please the court, I represent the interests of HALIA SMICH, the plaintiff in this matter. The lower court judge in this case misapplied the standard for summary judgment. She failed to visit all the evidence and all the reasonable inferences therefrom in a light most favorable to the plaintiff. She independently found facts favorable to the defendant on the issue of negligence, usurping the function of the jury, and she invoked a outdated catchphrase, sudden emergency doctrine, to basically rubber stamp the defendant's summary judgment motion and find the other driver in this case responsible 100% as a matter of law. This was a two-vehicle collision on the interstate highway. HALIA SMICH was a passenger in a van which was struck in the rear end by a moving truck operated by David Kieran.
So counsel, to that point, in the light most favorable to the plaintiff, was the rear of the van struck by the front of the moving truck?
Correct. That was the determination made by the state trooper accident.
So there was no side-to-side contact at all, or side of the van to the front of the moving truck?
She said it was front, she said the front driver's side of the truck to the rear driver's side, I believe, of the van. Yes, it was a rear end impact.
Okay. Now, no percipient witness stated that Karen was speeding. Is that right?
That would be correct, yes.
Okay. And did your expert witness opine that Karen was speeding?
We had a couple different factors in that regard. One is that speed can be inferred by a especially hard impact. That's one of the cases that I cited in there. That is our main point, is because the evidence gathered at the scene showed that Mr. Karen left 44 yards of skid marks before hitting the rear of the van with sufficient force to send it flipping down an exit ramp. Then beyond that, we had Mr. Benanti, an accident reconstruction specialist, analyze the skid marks at the scene. And he was able to make calculations from which a jury could infer unreasonable speed. I can explain that.
Oh, okay. The problem I'm having with this is I don't quite know where the line is between reasonable inference and something for which you need an expert. So I read your expert's testimony to say he would have been traveling 47 miles an hour if it were true that he was starting at 65 miles an hour, which was his testimony.
Correct.
You did not get your expert to say, and this crash must have taken place at a fast, he must have been going faster than 47. You don't even get him to say, and if, as the other driver said, McNeil, that driver was going 65 miles an hour, there would have been no contact between this 47 mile an hour vehicle and that other car, the van. You don't have an expert say any of that. So now you're saying a jury can reasonably infer that if in fact and I'm not a physicist, if in fact McNeil was going 65 miles an hour, this collision could not have occurred with the with the moving truck going 47 miles an hour at the point of impact. But how do I know that? The car isn't moving in a straight line. It's cutting across lanes. If you stay at 65 miles an hour, but you're cutting across lanes, what's your forward directional speed? I have no idea. I don't know anything about this. So how can a jury be asked to infer he must have been going more than 47 at the point of impact and therefore must have been speeding?
Well, first, if I may, I don't think that we need Mr. Benanti's calculations in order to prove negligence or a reasonable question.
No, but speeding, I will talk about attentiveness in a minute. I want to talk about the speeding first.
Okay. Well, first of all, I'm not trying to dodge the question, but the first point is that speed can be inferred by a hard impact. And there's actually a case, I believe we cited in our brief, where the one car rear-ended the other and the car in front rolled. And on that, which is exactly what happened here. And on that basis, it was permissible for a jury to infer speed.
I don't understand how that's supposed to work. They're going 65 miles an hour or more on a highway. I know now, if you brought in a reconstruction expert or a physicist or something who said, even if you're cutting in this direction and then you're hit, you wouldn't roll. But I don't know anything about that. I don't know where the center of gravity is in the red car. I don't know where the momentum would take it if it was cutting across and another car hit it. I'm not saying that you're wrong. I'm just saying I don't know how a lay juror is supposed to draw those inferences.
Well, once again, I think that the lay testimony is sufficient to establish speed. I do believe that, well, the record does show that the van was traveling at normal highway speeds. And if the van had been going 47 in a 65 mile an hour speed in a 65 mile an hour zone, it would have been noticeable to the passengers. They said everything seemed fine. So on that's the basis that I'm putting that he had to have been going well over 47. I don't think it's that close, honestly. But once again, it's not the case is not dependent on the use of expert testimony. In a case like this, we specifically said we don't believe we need expert testimony. This is something that's within the common knowledge of a juror without illumination from an expert.
If we're looking at the facts in the light most favorable to your client, did Karen brake or not brake prior to the collision?
The investigating state trooper found that he broke prior to the collision, and he left 136 feet of skid marks, which comes out to which comes out to about 44 yards, and that was prior.
Okay. Go ahead.
So based on the extent how long he had been emergency braking and still being able to hit the van with that much force, I think is enough for a jury to infer unreasonable speed out of that. I mean, once again, a jury needs to be able to hear this testimony. The judge chose to take it away from the jury based on Mr. Karen's testimony.
Okay, so I get you say that the speed can be inferred from the especially hard impact. Did you have a second basis that you felt like a jury could rule in favor of your client?
We certainly do. It's based on the differing testimony between Mr. Karen and the other driver, Mr. McNeil. Mr. Karen testifies he was driving along in the right-hand lane when suddenly a red blur appears in his peripheral vision. Moments later, he was struck by Mr. McNeil's van. Mr. McNeil testifies very differently from that. Mr. McNeil testifies he was in the center line approaching an exit. He realized he needed to get over to the right. He turned, he checked his blind spot, he looked back up, checked his passenger side mirror. At that point, he saw Mr. Karen's truck about 2 car lengths behind him, 25 to 30 feet. He looked at the truck for a number of seconds and then made the judgment that it was safe to move to his right, and the impact happened very quickly thereafter. So the point would be
the attentiveness argument.
Yes, definitely an attentiveness. Yes, and that was very clearly set out in the Orr fire case.
Does your expert say how many seconds the brakes were on before impact?
He did not. No, we don't have that information.
Both parties testify it was almost instantaneous. Is that right? McNeil and Karen?
No, Mr. McNeil, basically what Mr. McNeil is providing is a full-length film. He's testing about the activities, because what we need to.
But he says he moved to the right, and then how much later does he suggest impact occurred?
Well, once he moved to the right, very quickly.
Okay, but what makes you say that wouldn't appear like a blur to someone? I don't get that.
Okay, the point is that there is reasonable care. We have to judge whether Mr. Karen acted as a reasonable person, a reasonably prudent person under the circumstances. The cases state that the circumstances are not just the impact of the vehicles. The circumstances are the interaction of the vehicles prior to that point. And an accident, every accident would be a sudden emergency at some point. The point is that how did they get to that point? And that's what we have to look at in order to assess reasonable care. And that is what we're saying. The fact that it was a quick impact.
Are you asking that we conclude that there's a duty on drivers near a highway exit to anticipate that someone in a more left lane might abruptly change lanes to exit?
No, we're not asking that. What we're stating is that when a driver is on a highway and they see a car well ahead of them, they're approaching an exit, that car has its directional on, they have a duty to anticipate that car is going to pull over, and then they have a duty to try and act reasonably. Because Mr. Karen may or may not have had the right of way does not give him absolute right of way for the road. He's got a duty
at 65 miles an hour. Is 20 feet enough to change lanes in front of the car, leaving the driver who's being cut off, leaving that driver time to respond, or is it past the point of no return, or we don't know?
There was a number of seconds.
I'm asking yes, and I'm saying I have no idea. You say 20 feet. That's a few car lengths. 25 to 30 feet, yes. Okay, I mean, I guess I can infer something about that from being a driver myself. At a high rate of speed, at some point you're going so fast that you wouldn't presumably you know, you would want more. I don't remember from driver's ed, but I feel like you're supposed to have a car length or something for every 10 miles an hour you're going or something. I don't know. So my question is, could a reasonable juror infer that there's enough time with 20 feet? You don't have an expert say that either.
Yeah, once again, I don't believe that we need an expert.
So I understand that, but I'm trying to figure out what's a reasonable inference.
The point would be, it's not just that there were 25 to 30 feet for a second. He was in front of Mr. Karen's truck for a number of seconds. And Mr. Karen, during those number of seconds, Mr. Karen should have seen that truck in front of him with its directional on, and Mr. Karen should have known.
Causation is part of this. You have to show that he could have stopped or done something evasive to avoid the collision. Just showing that he hit him doesn't tell us, without more, doesn't tell us anything if it was unavoidable.
We're not asking the court to find that. Basically, what in the cases that we cited in our brief, it's whether or not there's enough evidence for a jury to consider. This case needs to be understood by a jury. A jury needs to be presented with the evidence in order to let them make the evaluation. That's an appropriate way that a negligence case should be resolved. And there is ample evidence to show comparative negligence on the part of Mr. Karen. We don't have to show he's predominantly at fault or even mostly at fault. All we have to do is show that the way he operated a vehicle was a substantial causal factor. And that means not something slight, not something tangential, but it doesn't even have to be but for causation. And one of the problems with this case is that the judge invoked the sudden emergency doctrine. And basically what that doctrine does, the problem with it is it focuses people's attention on the collision between the vehicles. But that's not what the law requires. The law requires that we look at the entire circumstances, the full movie, not a short outtake of when the collision occurred. And the judge applied that to grant summary judgment and to keep this case away from a jury when a jury had a right to hear this.
So counsel, I just want to make sure, because there was a lot of back and forth in the parties about the burden of proof, but he's come forward and he's saying, I was going 65, the other driver did this unexpected and very fast move. Other people say it was a very abrupt move, and you can't prove your case. And I want to make sure I'm understanding you correctly. You're saying we do have evidence of negligence. We have evidence that the van was speeding, that the moving truck was speeding, and we have evidence that the van signaled for a number of seconds before it made the abrupt lane change, and that those two things, either one of them would allow a jury to find for your client, right?
That would be correct in either of those situations. And there's a long line of case law going back to the 1930s that back that.
Did I miss anything? Is there anything else?
Or just once again, the fact that he did not have an unquestionable right of way under all circumstances. He had a duty to watch other vehicles, watch the situation, and operate his vehicle in a manner that he is able to react to foreseeable dangers. And that is what happened here, and he failed to do it, and therefore it should go to a jury. If there's no further questions.
Seeing none, thank you. Mr. Rosenberg.
Good morning, Justices. May it please the court. My name is Kath Rosenberg. I represent David, Karen, and town-to-town movers. The motion judge ruled on the entire record in this case and concluded, as we argued at the trial court, that this is a case of sudden emergency. Even if we were to view the case simply on whether the defendant is negligent, and I'll speak to that, it really is a case of sudden emergency where, according to Offerer versus Biswanger, the court said that on certain facts, if there's a sudden emergency, a trial judge should rule as a matter of law that the crisis that was facing the driver, that the driver had an appropriate response or reaction to the crisis, measured as a person of ordinary competence under the circumstances. And that's what the motion judge found, was that Mr. Karen's response to a vehicle cutting him off when it was only 25 to 30 feet in front of him in his lane, when he was at 65 miles per hour, his reaction or his response was entirely appropriate under the circumstances that was before him. The plaintiff's argument that somehow speed was a factor or that the right blinker was a factor has no merit here. There is no witness in this case who has placed any speed on Mr. Karen in excess of the speed limit of 65 miles per hour. Even if we believe that Mr. McNeil operated a right signal in the middle lane, it is not reasonable that a driver in Mr. Karen's position is going to know or should know that this car is going to swerve in front of him when it's only 25 to 30 feet away at a highway speed.
How do
And
we
to
know?
answer- yes.
How do we know that 25 to 30 feet isn't enough at highway speed?
25 to 30 feet is the distance of, well, several reasons. One is the plaintiff's own expert, Mr. Bernante, in his affidavit talks about a perception reaction time of 1.5 seconds, that before a driver can even react and perceive an event in daylight, it's 1.5 seconds. At 65 miles per hour, it's a mathematical equation that a car is going to travel at least 25 to 30 feet, if not a lot greater, during that time interval of 1.5 seconds before the driver can even react.
But both cars are continuing to move forward. It didn't hit a stopped car.
Yes.
I mean, I have no idea what the answer to this is, and maybe that's a failure of the plaintiff to put enough in the summary judgment record. I have no idea how much time, how much distance you need before changing lanes in front of a car at a given speed. Do you? I mean, I have no idea.
Well, I think I think Trooper Benanti in his affidavit opined as to the reaction perception time, but Trooper Renzi, which as part of this record, concluded that when the van cut into the lane that the moving truck was traveling in, she's an accident reconstructionist who certified that there was not enough time to avoid the accident. So we presented that argument and that evidence as part of our summary judgment, and the plaintiff did not provide anything to contradict that. So to answer, Judge Rubin, your question, I think that Trooper Renzi considered that. Trooper Renzi also considered the fact that even if Mr. Karen had time to brake pre-impact, that did not change in any way his ability to avoid this accident. She said this was at a point of no return when that car entered his lane at that distance of 25 to 30 feet, and said there was nothing a driver could do to avoid this accident. I think that the plaintiff, to have overcome the summary judgment, needed to present some type of affirmative evidence as to what Mr. Karen did to contribute to this accident. We don't have evidence of speed. We don't have evidence of inattentiveness. We don't have evidence of distraction. We don't have evidence of tailgating.
Okay, so counsel, I understand what you're saying about the turn signal, that even if the turn signal was on, I take it you, for purposes of summary judgment, we will infer the turn signal was on for several seconds, is what the record said. But you're saying that in and of itself is not enough because that doesn't, where there's clearly not enough room, you can't just change lanes just because you put on a turn signal, right? So that we'll put that aside for a minute, right? But that's your position. All right, so then going to the speed issue, if it seemed like his expert or one of the two experts said, okay, let's take it at face value that Karen was going at 65 miles an hour. And if he was, and the trooper decided he braked, that the time of the collision impact, then he was going 47 miles an hour. And the other parties all seem to say that the van was going at a normal highway speed. So that seems to be a dispute of fact. How was that not a dispute of fact?
That's not a dispute of fact. Let's all agree that Mr. Karen was traveling 65 miles per hour and was 47 miles per hour at the point of impact, and that Mr. McNeil was traveling at 65 miles per hour. As Justice Rubin pointed out, Mr. McNeil is cutting across to go to an exit. Nobody knows what speed Mr. McNeil was going as he was cutting across to take an exit. And this isn't a rear end accident where one vehicle is traveling behind another vehicle for some distance. This is a vehicle cutting into someone else's lane, the points of contact, as I understand it, was corner to corner. This wasn't a flush rear end vehicle where a driver has enough time to avoid the accident. Although Mr. Benanti does these calculations, nowhere in Mr. Benanti's testimony or affidavit does he form any type of expert opinion that Mr. Karen failed to exercise due care. He doesn't say that Mr. Karen was speeding. All he does is calculate what, by measuring skid marks, what he determines Mr. Karen's final speed was at impact. There's nothing in that record that says Mr. Karen was speeding on any of that analysis, Your Honor.
What's the best record site that the impact was corner to corner? Because I did spend some time looking at this very voluminous record, and it wasn't jumping out at me. I'll just say that, and this seems like an important point.
I believe it was Trooper Renzi's testimony. I believe it is in her accident reconstruction report. I don't know whether that's part of the record or not, but certainly her testimony is.
Okay.
And this is an accident, as every witness has testified, happened very, very quickly. So the question really becomes is that Mr. Karen, traveling in his own lane at a highway speed, is faced with a vehicle cutting him off. And what is his response or reaction? Was it a reasonable response in consideration of what other motorists would do under the circumstances? And that's what the trial judge found and ruled as a matter of law, as she's entitled to under the sudden emergency doctrine. And I still go back that if we're just analyzing it as a pure negligence case, where is the evidence here that the plaintiff has presented in the record that Mr. Karen did anything to contribute to the accident? There just isn't any evidence, Your Honor.
So, counsel, one thing that concerns me is that the judge wrote in her memorandum in order that McNeil himself admitted that he made an unsafe lane change. So obviously the judge wrote that, but in the underlying testimony, you know, I don't see him saying that actually. So I worry that's a finding of fact. She can't make a finding of fact. All she can say is that the facts are disputed or they're not. McNeil seems to say in hindsight, it was not prudent or wise for him to change lanes. What's the best site that he himself says it was unwise?
I know that plaintiff's counsel provided a soliloquy of some questions and answers where initially I think he didn't answer that, but I believe later on he does admit, looking back, that it was an unsafe lane change. And I apologize, Your Honor, I don't have the exact part of the transcript of his testimony where he does say that. But
well,
whether—
we've got an 800-page record here.
Yes. But whether Mr. McNeil, whether Your Honor is considering that a factor or not, what the judge concluded wasn't simply based on Mr. McNeil. The judge concluded based on the testimony of everyone in this case. I know the plaintiff's counsel argued that this is just Mr. Karen's testimony that she relied on. She relied on the testimony of both plaintiffs that this vehicle moved over very quickly or in a sharp manner. She relied on the testimony of Mr. McNeil, certainly, relied on the testimony of Mr. Karen, relied on the testimony of the accident reconstructionist, relied on the affidavit of Mr. Benanti. She had the entire record before the court. And in those 800 pages, or whatever that record comprised, there was not one fact which could lead a reasonable jury to conclude that Mr. Karen failed to exercise due care under the circumstances of this accident. And the plaintiff failed to meet the burden. Had he hired an expert to give an analysis and concluded that Mr. Karen failed to exercise due care, then it would be a jury issue. But you need more than just guesses and convoluted math to get this case to a jury. A jury has to have some facts that they could look at as to what Mr. Karen did to cause this accident. And there's nothing in the record, Your Honor. When I think the plaintiff's counsel also focuses on what he calls the precipitating events leading up to this accident, and that somehow Mr. Karen was responsible for creating his own sudden emergency. There's just no evidence of that. And even if one were to break down the precipitating events, you have a van traveling in the middle lane, you have a truck, moving truck in the right-hand lane. let's assume the van turns on its right-hand signal, and at some point that van swerves into the right-hand lane. Where are any of those precipitating events showing that Mr. Karen didn't pay proper attention? As Your Honor indicated earlier, I don't think it's reasonable to anticipate, even if there's a signal, that some car or van is going to turn right in front of you. And 25 to 30 feet, I mean, I think there's ample evidence that that is just such a short period of time in an instant, that what can somebody do reasonably to avoid this accident? And as the motion judge concluded, there wasn't enough time. And she did look at the sudden emergency doctrine and adopted that, which the officer court says, as a matter of law, the judge should rule that if the response or the reaction measures up to a person of ordinary competence acting under the circumstances, this case should not go to the jury. If there are no other questions, Your Honors, I will rest on my brief.
Okay, seeing none, thank you both. Thank you both. We'll take this under advisement.
Thank you.